Welcome to On the Agenda, Steptoe's guide to state attorneys general and other enforcement, regulation, and compliance matters. From AI to smokestacks, consumer protection to financial services, data privacy to antitrust. Join Steptoe's seasoned litigators, counselors, and advisors as they deliver the critical insights and industry knowledge that government officials respect and that companies, nonprofits, and executives can use to navigate whatever legal challenges they face.
Hi, I'm Michelle Kallen, and welcome back to On the Agenda. I'm a partner in Steptoe's Washington, D.C. office and co-head of our appellate practice, representing our clients in trial and appellate courts throughout the country. Before joining Steptoe, I served as Solicitor General of Virginia. This week, we're pleased to speak with New Jersey's Solicitor General, Jeremy Feigenbaum. And I'm once again joined by my partner, Eric Berman. Hi, Eric.
Hi, Michelle. It's great to be doing this with you again. Hello, everybody. As Michelle said, I am Eric Berman. I'm also a partner in Steptoe's DC office. I'm in our consumer litigation group where we represent clients in private litigation, government litigation against the state attorneys general, the FTC, and the DOJ. And I'm really looking forward to this discussion today.
So we are thrilled to have you here, Jeremy, to discuss your work as Solicitor General of New Jersey and working in a state AG's office generally. So welcome.
Thank you so much for having me on. I'm thrilled to be here.
So before we kind of jump into the details and content, can you share a little bit about your background and what brought you over to the New Jersey AG's office?
Sure. So I was the rare breed who always wanted to work in state government. I think going back to college, certainly going back to law school. And I was from New Jersey. It was a natural home for me. So after college and law school and 2 clerkships and a brief stint of my own at a law firm, the moment that I had an opportunity to come work for the New Jersey government, I took it. And so at the start of this current governor's administration, the Murphy administration in New Jersey, I begged anyone who would listen to hire me. And I was brought on by the Attorney General to serve as his counsel. And so I worked for a couple of years as counsel to the Attorney General before I took my current role.
And did New Jersey have a Solicitor General at that point?
Michelle, you're setting me up for the best questions here. So when I arrived to the New Jersey Attorney General's office, there was no Solicitor General position and no Solicitor General's office. And I think New Jersey had centuries, really, of a storied litigation history, but we were really in the minority of not having an SG's office anymore. And I thought we were losing out on the benefits that came from having an SG's office. And so after spending about 2 years working as counsel to the then Attorney General, Gurbir Grewal, I put together this, some could say psychotic, 30, 40-page single-spaced memo in which I proposed that we create a Solicitor General's office, not because you need it for all the work of the state. There's so much great work that New Jersey was already doing extremely well, but because there are benefits, like many law firms have with their issues and appeals groups, there are benefits to having targeted appellate specialists that can be generalists across a range of civil and criminal issues that can dive in on some of the state's highest priority work. And so I interviewed something like 30, 20 state solicitor generals about why their office existed, how their office worked, et cetera. And I proposed to the then AG that we would create this SG's office and not so subtly suggested, hey, maybe there's a guy who's now spent a lot of time thinking about state SG's offices. And man, don't you think he'd be good in that role?
We would say passionate, not psychotic, by the way. I'm sorry to jump in, Michelle.
Yeah. I should learn to talk about myself in a better way.
That's amazing. So not only do we get the Solicitor General of New Jersey, the first Solicitor General of New Jersey, we get the inventor of the role of Solicitor General of New Jersey. That's a triple treat for us here.
Yeah, you are talking to both the best and the worst Solicitor General New Jersey has ever had.
Well, that's awesome. So given especially your expertise in interviewing different offices, as you and I both know, having met through the state SG world, each office functions very differently. So what was that you envisioned for the role, and what is the role now, and how does that kind of compare to the role generally in other states?
Yeah, there seem to be 2 or 3 models in the way that states really break out their SG's offices. So obviously the United States has an SG's office that is focused principally on SCOTUS. No state ever has enough cases at SCOTUS to justify an office that is based entirely on SCOTUS. And so no one is structured that way. We're all structured differently. Some states, I'm thinking of the New York Solicitor General's office, the DC Solicitor General's office, essentially do 100% of their offices appeals. That tends to be in offices which have a smaller criminal caseload, because the criminal caseload for an AG's office in a state like New Jersey can number in the thousands, and it's not possible for one office in an SG's office model to do all of that kind of work. Most offices have a model where we focus principally on a series of the courts that matter to us most, and then a series of the cases likely to have the highest impact for the state. And so, again, I mentioned issues and appeals group. The way I think of the New Jersey Solicitor General's office is an issues and appeals group within the broader New Jersey Department of Law and Public Safety. We focus principally on the US Supreme Court, on the Third Circuit, and on the New Jersey Supreme Court, and on our multi-state litigation work. And we also focus in any court on constitutional challenges to our statutes, executive orders by our governor, et cetera. So we make sure that we're involved and are putting some of these incredibly talented attorneys I've been so blessed, honestly, and we've been able to recruit both from New Jersey and from across other states to come in and work in the New Jersey SG's office. And we're able to leverage them principally on SCOTUS Third Circuit, NJ Supreme Court, multi-state work, and constitutional defense.
And how big is your office now?
One of the nice things about being a first state SG is that it's allowed us to have a flexible model to adjust to the dockets and the cases as they began. So I actually just hit 5 years this month. When I started, it was a one-person SG's office. It was just me. And that was true for about 6 months. I highly recommend never being an SG without an SG's office. It's not a workable system. But 6 months in, I got my first 2 deputy solicitors general. And then after that, we built out a fellowship program. So for a long time, we hovered in the 4 to 8 range. We've recently grown in part because we've developed a bunch of new work outside of the Third Circuit and New Jersey Supreme Court. We find ourselves in the US Supreme Court in cases like birthright citizenship. We find ourselves doing a brand new world of gun safety litigation, both defensive post-Bruin and affirmative vis-a-vis, the rollbacks coming out of the ATF. So as we find ourselves in new work, and as we find all these incredibly talented federal government attorneys who are looking to stay government attorneys, we have hired a fair number of folks who come from US DOJ. So we're currently clocking in at about 12 attorneys, which is a big change from where we were just 2 years ago.
No, you were great. And actually, Jeremy kind of, segued into what I was going to ask about, which is about litigation priorities, right? And we figured you would mention birthright citizenship. We obviously want to hear more about that. Gun safety, particularly at the Third Circuit and the U.S. Supreme Court level. What other litigation priorities would you say your office currently has?
Yeah, so our Attorney General has a range of priorities, and then I can talk a bit about the SG's office priorities in particular. The AG has a range of priorities. He has long been focused on issues around gun safety. He has long been focused on issues around public integrity, and that can be both criminal and civil. And he's long been focused on issues around big tech accountability, whether that's consumer protection, data privacy, antitrust, et cetera. So those have been 3 big priority areas for New Jersey Attorney General Matt Plotkin, the Attorney General who I now work for and who I've worked for the last 3.5 years. And so a lot of our work has, at various times, reflected those priorities. So a lot of my work in the Third Circuit in recent years, especially in the wake of Bruin, have been Second Amendment challenges to New Jersey firearms statutes, whether that is our assault weapons law and our large capacity magazine law, our laws about sensitive places like playgrounds and schools, our laws about people who have committed a series of crimes not being able to carry guns anymore. So some of it comes from that priority area. A lot of our work, especially in the New Jersey Supreme Court, can come from the public integrity space. So we had a criminal conviction or a criminal charge get thrown out by a trial judge who said that mere candidates who take bribes for things they promise to do if they get elected can't themselves be violations of the bribery laws if they don't get elected in the end. And so they're never able to make good. And we, of course, think that the agreement, if you get elected to do that, is itself a violation of the bribery law. So that's a great case. The Solicitor General's office got involved. It was a criminal case about whether candidates who take bribes have violated New Jersey bribery law. Thankfully, the answer 7-0 in the New Jersey Supreme Court was yes, that is illegal. That is criminal. You can't take bribes even as a candidate. So a lot of our work has reflected those areas. The truth is some of our work is also outside of our control. So some of our work is affirmative work. But in an SG's office, a lot of your work ends up being defending major priorities of what the legislature passes, what the governor enacts, what policies the attorney general has adopted, because those are the ones that tend to get challenged in federal court. And so we find ourselves in a lot of our work in the Third Circuit defending a range of New Jersey statutes. We defended our restrictions on the distribution of alcohol from a dormant commerce clause challenge. We are defending our restrictions involving veterans consulting in a case called Veterans Guardian from First Amendment challenge. So we're seeing a lot of First Amendment challenges, dormant commerce clause challenges, Second Amendment challenges as well. And so we're doing a range of those. At the US Supreme Court, the picture's a little different. At the US Supreme Court, we find ourselves less frequently there, but when we're there, it tends to be, in my view, a little more idiosyncratic based on the interests of the justices rather than the particular things that New Jersey is focused on at any given time. So, for example, we have two cases at the US Supreme Court coming up in this Supreme Court term. We have First Choice versus Platkin, which is a case about whether challenges to a subpoena that we issued are ripe in federal court. And we have New Jersey Transit versus Colt, which is about whether New Jersey Transit, our principal public transit agency in New Jersey, has sovereign immunity, or because it's a separate entity that has its own sue and be sued authority, whether it lost sovereign immunity. Really interesting cases. The last thing I'll say on that is sometimes the work that arrives to the US Supreme Court is the work that we're doing in the multi-state space, in the federal facing space. I suspect I will get some questions about that, so I will reserve birthright citizenship to those questions, but I at least wanted to note, obviously, that while I'm mentioning the cases that make their way up through the Third Circuit, or our sovereign immunity cases that we're taking up ourselves to the US Supreme Court and are a little more idiosyncratic, there is also that separate world of multi-state work, which is, by the number of cases we carry, a fraction of the work that we do, but of course can take on outsized importance, and I realize that.
And our audience should know that Jeremy argued the birthright citizenship case about nationwide injunctions just this past term. It was probably the biggest case of the term. And I have to say that he just did an incredible job. People in the kind of Supreme Court world were texting, like there were text threads of, oh, who's this Jeremy guy? He's fantastic. And a number of people knew you before, but those who didn't obviously knew you after the argument. It was just one of those outstanding arguments that really people noticed. And I think genuinely made a really difference in terms of how the court issued its decision. So it was really exciting. And I look forward to hearing you argue more cases before the Supreme Court.
I am so glad that this is a podcast and therefore audio only, so that there's no recording of how much I'm blushing right now. But Michelle, that is really lovely of you to say. It was a very fun experience. It was a very interesting experience. So I like to say, I think I am the first person to have pulled the hat trick of an oral argument from the emergency docket, the original docket, and the regular merits docket. Think I am the first person to have done that. It is a totally random trivia fact. It's not as though it's any sort of claim to fame. Many people are more experienced than I am. But so this argument was obviously very different from what we had had before. So I had argued two cases before. One case was called Penn East Pipeline. It was a case about state sovereign immunity with respect to condemnation by a natural gas pipeline. It was a sort of normal merits case. It got granted on a cert petition by Paul Clement. We had briefing, we had oral argument. Okay, we know how that goes. The Supreme Court bar know how those cases go. Then I had an original jurisdiction case, New York versus New Jersey. That was weird because it was an original jurisdiction case and we didn't have a special master. So what we had done was file a motion to dismiss and a cross motion for judgment on the pleadings, and everyone went on their motions. And then we had argument on these motions. But okay, there was briefing, orderly, oral argument. This case was obviously different. This case was an emergency application from the federal government that we had 3 weeks to respond to and 40 pages to respond to the whole world of things we might be interested in. Whether this was going to be cert-worthy on the issues they had taken up, what was the right answer on the issues they had taken up, whether the equities favored coming up on this posture, whether there was an irreparable harm to justify a stay pending appeal. So all of that in 40 pages. And then the US Supreme Court drops an order that says, we would like to have argument on this one. And the wild thing for everyone involved is you just have no time in an emergency oral argument preparation. And I had my own Third Circuit argument 2 weeks exactly before that. So I had this really crazy 14-day period just to start getting ready for Trump versus Casa and the oral argument. And in some sense, it was exhausting because it was 14 days of really trying to hunker down and canvass the world and history and policy arguments and first principles arguments and everything that a court might ask you about on universal relief. And also at the same time to develop as much as possible incredibly detailed, factual, record-based information about why we were not a case that was a particularly good opportunity to destroy universal relief, because our nationwide injunction was uniquely based on special concerns we had about harms to us as states and about the workability of systems in which citizenship turns on or off when you cross state lines. And so from that perspective, we ended up kind of thinking of this as two completely different cases and finding a way to marry them at the podium. One case was the story of the universal injunction and how much to defend universal injunctions and what 23 states' different views of universal injunctions were. And one case was the intense factual record of how does a social security number work? What does it mean to verify someone's citizenship? I myself had to go into something called STEVE, which is my favorite acronym I learned in this case, the State and Territorial Exchange of Vital Events, which is how you find out when people move across state lines. So when I'm up there saying 6,000 babies are born to New Jersey parents out of state in a given year, I'm using this number we get from Steve. So in any event, it was a really interesting case and a really good reminder that in all these cases, even at the US Supreme Court, you're not just supposed to be like a highfalutin, like lawyer. When you're at the US Supreme Court, you also have to be able to marshal your case and your facts and your record to be able to tell a particular story. And that's what made that argument so fun. I mean, I had a great time. I can't say I had a great time prepping for it the night before I turned to my husband and said, maybe I never want to argue a case again. But the day of, I had a great time.
Yeah, well, it was, and the fact that you had fun up there or were engaging in a meaningful way really shone through. It made it an exciting argument to listen to. And now the case went back down. You all now have nationwide relief as states. So what's the status of the case and where do you see it headed in the next bit?
Yeah, so after Trump versus Casa, I know that there was some reporting that the nationwide injunction was dead. And I think that was a bit of a misunderstanding. The universal injunction was dead. The universal injunction, as Justice Barrett explained in Casa, was an injunction specifically designed to grant relief to non-parties that they said didn't exist in the relevant statutes from the founding. But they left open, they didn't say they still exist, they left open for future cases, whether in this one or another, that you could still have nationwide relief when you have a class action of nationwide scope, when you have states that need it for complete relief, or when it's made available by a statute. And so they left for another day an incredibly interesting question in the law about whether the Administrative Procedures Act allows for universal relief through what's known as vacatur of an agency action. So very consciously, to her credit, Justice Barrett made clear that even as she was announcing a very clear holding about this concept of universal relief under the statutes from the founding, she specifically said the things they were not deciding. Did states have standing? Did we need it for complete relief? Could a class action be certified here? If there were agency actions built on the CO, could they be vacated? And so on remand, we went before the district judge and said, you, district judge, always gave us a nationwide injunction because we needed it for relief. And Justice Barrett herself recognized that had been your basis. She reserved for another day if you were right or wrong, Judge Sorokin, but she understood you had done it consistent with her instructions. So let's build a factual record now on why we really need it. And the US, I think somewhat remarkably, and Judge Sorokin in his opinion suggests somewhat remarkably, refused to build any factual record. They are building no factual record about any alternative that would give the states relief in a way that is workable. And so Judge Sorokin said, I have this very detailed factual record from the states. I have no factual detail from the United States. I will do independent investigation as well, but I'm making factual findings, both based on my assessment and the record in front of me, that this is necessary for complete relief. I think clearly right on the facts in front of him. And so we now have that district court decision. We have a nationwide injunction, and there's now a nationwide class that's also been certified in the same space that also has a nationwide injunction. And all of us are before the First Circuit tomorrow, where we're going to be arguing our position on the merits, arguing our position about nationwide relief again. And so one of the things about these emergency cases is that there's always something. Every month there's been something in the birthright citizenship case. But I think it reflects the stakes of this case. I mean, let's not forget this. SGs spend a lot of time thinking about things like standing and scope of relief and a lot of these very important but sometimes wonky issues. But let's not forget what we're talking about in this case. We are talking about whether babies born in America are American citizens and whether we're going to follow a rule that goes back to English equity and English common law. and whether we're going to follow a rule that has been the precedent of the United States Supreme Court for 127 years, has been executive practice for over a century, and is reflected in statutes that Congress adopted in 1940 and again in 1952. I mean, this is a really big fabric of what it means to be an American in this country. And like the policy or don't like the policy that the president adopted on his first day in office, it's a really big deal to rewrite the rules of citizenship by executive order with the stroke of a pen mere hours after taking one second term. So I think the stakes couldn't be higher, both for the rule of law, but also for like very real people, millions and millions of birthright citizens that live in this country right now and that are being born every year.
I'll just say, because I don't live in the SG world the way that Michelle does, listening to you advocate here in a podcast forum makes it very unsurprising to hear Michelle report about how people were saying how well you were doing. And it's coming, whether it's audio or video, it's coming through the screen. So it's fascinating to listen to. I did want to touch a bit more on federal state dynamics. Obviously, that has permeated a lot of this conversation. Your office was created in 2020, right? So you had 4 years of Biden and now the change in administration. At the risk of this being maybe a third rail type issue, we can all read the news. But how would you describe New Jersey's relationship with the federal government? Are there areas of agreement, or is it all, acrimony? Give us a little inside baseball on that.
Yeah, I mean, there's a couple dimensions on which I could answer this question. The first is there's obviously so much overlap in the institutional interests of these two government entities. So when you think as a litigator and a solicitor general, there's plenty of cases where we think that we and the federal government should remain aligned. Criminal law cases in plenty of cases, institutional interests like immunity, sovereign immunity, interests typically in things like Article 3 and standing. These are very wonky SG style answers, so I'll give you like a 30,000 foot answer also, but there's always been areas of overlap. And in the first Trump administration, there were plenty of areas of overlap with states regardless of ideological persuasion. In the first Trump administration, we were able to continue working really closely with our U.S. Attorney's Office too. I saw this when I was counsel to the Attorney General too. We had a really close relationship with our U.S. Attorney's Office. I think that's really important when it's possible. There have to be two hands coming together, one on each end, to be willing to continue those collaborations, but as much as possible, trying to keep the politics out of law enforcement work that we all do together, breaking up fentanyl distribution chains, dealing with interstate traffic to felons of guns, dealing with things like ghost guns. These are real world problems. We worked really closely with the first Trump administration's U.S. Attorney's Office as well. Of course, again, with the Biden administration, but those sorts of issues really shouldn't change, and politics shouldn't pollute that. Obviously, the last 6 months have been a challenge for broader collaboration across governments, and we recognize that, and we know that that's been quite tough. I'm a perpetual optimist, I guess, and so I would say I remain hopeful as ever that some of the most basic functions of government, we will do our best to find ways to continue working together. But it's tough. It's tough when the federal government is slashing our law enforcement money, when they're slashing our transportation money, when they are slashing or conditioning money we're supposed to use on victim services. These are things that the first Trump administration didn't touch at all. So, the first Trump administration in New Jersey had big fights over policies about whether and when state and local law enforcement officials work with federal civil immigration officials. We work with ICE human trafficking entities all the time, but civil removal, New Jersey is one of the states that has some limits. We have some collaboration, but some limits on when we'll work with ICE in that respect as we build our own relationships with our victims and with our witnesses, even when they're undocumented. And okay, we had litigation in the first Trump administration, but this time DOJ is conditioning money for victims' services on whether or not we have these sorts of policies. This is VOCA money. It's a huge formula grant. It's a really big deal. And they have recently made clear that they want to cut victim services money based on fights over immigrant trust policies, or what they call sanctuary policies. It's remarkably unfortunate. It was the same when we were in litigation with FEMA. It was the same when we were in litigation with the Department of Transportation. These are entities, I don't remember too many lawsuits against the Department of Transportation in the first Trump administration, because everyone needs functioning public transit, everyone needs functioning roads, everyone needs our airplanes to take off on time when they do. And so, there are some really important day-to-day things about just government working for people that governments really need to prioritize and need to, I think, care maximally about, well beyond the political roadshow that I know makes for better spots on TV. And I think it becomes unfortunate when some of the political fights and the splashy shows infect even our most basic governance.
I do a lot of consumer protection work with the Federal Trade Commission, and I often find myself telling clients, Republican commissioners don't like fraud either. A lot of what unites us, really should overwhelm what divides us, and often that's true.
We continue working with the federal government on antitrust cases. There are active antitrust cases right now where they are a plaintiff and we are a plaintiff, or one of the leads for a broader group of states. One of the things I was heartened to see, and this is a question a little bit about government collaboration, but with other states rather than with the federal government, is that contrary to popular belief, there is still a lot of cross-ideological collaboration across state SGs and state AGs. And so state AGs are doing a lot together in the consumer protection space. We're working together in opioids cases. I know that's a really prominent one that folks are aware of. In tech accountability work, in antitrust work. Those have been spaces where Democratic AGs and Republican AGs have found a lot of common ground, and I think make our voices much more effective together because we're able to collaborate. The SGs see a little less of that work because, as you and your listeners know, most of those cases don't always go on appeal because a lot of them end up settling or end up in years of discovery. So I can't say personally that I've had the same huge imprint in some of those cases as some of the attorneys general have, but I think that's a really, really important space for multi-state collaboration.
How are you seeing kind of the multi-state dynamics, especially as the federal dynamics ebb and flow? Is there, in your role and across the SG world, is there still kind of bipartisan dynamics? I just remember NAG was so pivotal when I was in the state AG world. And then it seemed like even just during my time in state government, there became increased focuses on DAGA, the Democratic Association of Attorneys General, and RAGA, the Republican Association of Attorneys General. So what's your experience been in terms of multi-state political dynamics between blue and red states?
I think for the SGs, NAG is still a very important role, and that's where we do a lot of our work together. Obviously, there's going to be multi-state work we do that has an ideological valence, and we understand that only some states and AGs are going to be interested in doing it. But NAG continues to remain, and I'm sorry, I should say for the listeners, NAG is the National Association of Attorneys General. NAG is an organization that brings AGs together, helps coordinate a lot of the work that they do together, brings SGs together for an annual conference. I was just in Seattle a couple weeks ago with SGs across the ideological spectrum, and it was wonderful. It was great to be together with SGs with very different views from mine and SGs with very similar views from mine. And we very much were able to have both good personal relationships and hopefully have productive work relationships as a result. So I have found in the SG world that everyone wants to find these opportunities to work together because we know we are advocates. We are advocates to courts. We know that for courts, it matters so much more when they see a cross-ideological group of SGs rather than a brief that's just, 20 states with one ideological persuasion. My favorite vignette about that is that one of my most important cases in my career has been working on the defense of DACA. And I was lucky enough to argue twice in the Fifth Circuit in defense of DACA. And in one of those arguments, I was up against the Texas Solicitor General, who was challenging DACA. New Jersey was the intervener defendant. And we were sitting in the lawyer's lounge together and talking about, the minutes before oral argument, whatever people talk about in a lawyer's lounge. And I mentioned to him that an upcoming US Supreme Court case, that I thought he might actually have interest in supporting me as amicus, because I thought that my arguments were not ideological, were aligned with state sovereignty interests. So even though we're there in a lawyer's lounge about to argue against each other in this high-profile DACA case, we're actually in the lawyer's lounge talking about New York versus New Jersey and state sovereignty as it relates to interstate compacts. And lo and behold, Texas ended up leading a multi-state amicus brief in support of New Jersey in that case, and it built a relationship on some of these sovereign immunity issues, or sovereignty issues. And so when we had this NJ Transit case with a cert petition just a couple months ago, Texas wrote the multi-state amicus brief for us, advocating for cert on these interesting sovereign immunity questions. I don't think most people who look at the politics that exist today think, hey, that New Jersey Solicitor General, and it's been a couple over the years since I've been here, but the New Jersey Solicitor General's office and Texas Solicitor General's office, I bet they have a great relationship on issues of state sovereignty and sovereign immunity. But the reality is we actually do, and we work really hard to make sure we're not going to agree on plenty of things. We didn't find common ground on DACA. We argued very passionately against each other in DACA, but we are going to find ways to agree on things like NJ Transit's sovereign immunity. And that might be enough for keeping relationships going.
Well, and that's something hopeful in this day and age, right? Where there's so much division, to see places of unity is exciting. Well, as we close out here, so for young lawyers who are interested in potentially appellate work or public service, do you have, as a closing message, any advice to offer to them?
Michelle, you keep setting me up for such great gifts. Other than, of course, going to work with Michelle and Eric, I would say come work at a state solicitor general's office. That's obviously the pitch I would end with for young attorneys. No, I joke, although I mean it. But I really think doing issues and appeals work and state AG work is some of the most interesting work that exists right now. States, in my view, are really where the action has been happening for a long time. States are doing good things, bad things, crazy things, whatever your perspective. And they're trying all sorts of different things. It's sort of, you've learned in law school, this idea of laboratories of democracy, but it's very real world. States are trying really different and interesting experiments in policy and governance and what it means to be running a state. And SG's offices get to be a huge part of that because we get to litigate. We get to be the tip of the spear litigating all the interesting things that a state is getting to try. So if folks want to find a way in their life to live an interesting life in the law and get to work on a range of crazy cases in state court and federal court, et cetera, then either being in a state SG's office or being in an issues and appeals practice and a state AG practice that interfaces a lot with states, I think, I'm a state snob, I think ends up being infinitely more interesting in one's life.
Well, that is a perfect way to close out. And on behalf of Michelle and Steptoe, Jeremy, thank you for joining us for this. This was a fascinating discussion. 30 minutes felt like 5 minutes, at least for me. So very much appreciate your time and looking forward to what you'll be doing tomorrow and in the future.
Thank you so much. It was great to join you both.
Thank you.
Thanks for listening to On the Agenda from Steptoe. Subscribe in your favorite podcast app so you don't miss future episodes. To learn more about Steptoe, visit steptoe.com. When the stakes are high, experience matters.